Good morning. It is 11 a.m. on Friday the 9th of October. My name is Arran Hunt. I'm a partner here at Stace Hammond and I head up the Migration Partners team. Now, as always, this video should not be taken as being legal advice. It is merely our review of changes in immigration within New Zealand. If you want legal advice, contact us directly by email or by phone. We had planned to make a video earlier this week about essential skills and work to residence visa holders. However, urgent matters have meant that I've had to focus on those rather than doing a video. However, that has been kind of beneficial as we've just received the long-awaited changes to the rules for work visa holders offshore. So this video will touch on those recent changes and those coming up shortly for work visa holders, including the right to re-enter New Zealand for work visa holders who are offshore. It also covers those resident visa holders who were offshore on a work visa, left the country and then were granted residence while offshore. For those of you who watch for partnership visa information, this video may only apply if your partner has a work visa and is offshore with you. For partners of New Zealand citizens and residents, this won't be so relevant a video for you. However, I did want to quickly point out the work on raising the issues that you are facing that's being done by those protesting recently outside the Prime Minister's office. My partner and I will be joining you there tomorrow morning as part of that protest. Now, looking at first of all, we're going to touch quickly on the low-skilled work visas for those who are in New Zealand. There's been a change on this in the last week. So, of course, now it's not much low skilled, it's those who are earning below $25.50 per hour. Recent changes come through that may make future visas sort of easier or harder to get. So such roles have previously required a skill match report from MSD or from WINS. Basically that skill match report saying that there's nobody available on their books for that role. And so the changes to that is coming in two parts. There's a detail under WK 2.1 in the operational manual. So for jobs that Immigration New Zealand considers are oversupplied, so there's too many people who are doing that job or too many Kiwis there to do the job, a visa will no longer be possible. Employers will need to engage MSD to recruit New Zealand job seekers. Now, I'll provide a link to the list in the description below. It's about 50 or so jobs in there. Includes some jobs like cafe worker, sales assistant, labourer and general receptionist, amongst a number of others. Now, for jobs that INZ considers are undersupplied, so there's a great demand for employment and not many people to fill the jobs, no skill match report will be required. Now the list of those jobs is region based, so if you go to the website, we'll provide the link below, you click on the area whether you're in or you're looking to find work, and it will list in there what jobs are considered underskilled. And there are a number in each region. Hey, look at Auckland, there was nursing in there, there's a few other ones in there. Now these are temporary changes, they will be reviewed in 2021. These are of course for visas that only last 6 months, so these are under a current requirement, I think goes through to about January 2022. These visas for people earning under $25.50 only last 6 months rather than a year. So if you can get a wage of $25.50 or more, then try and do that, try and get that wage up there, because that would then look at possibly getting a 3-year visa rather than a 6-month visa. The other issue with the 6-month visas, you only have so many before you have to leave the country for a year. So that 3-year visa available under $25.50 payment or higher is definitely a better option to go with if you can. It would also remove this requirement. So this requirement to look at whether if it's oversupplied does not apply to those jobs which are at or above the median wage of $25.50 per hour. Okay, now let's move to the main event, entry to New Zealand for work visa holders. Now this was initially announced on the 9th of September and we did a video on it back then. We sort of hinted that it was coming, I think a day or two before that, and then it was announced, and now we have the rules. Now these appear in Amendment Circular 2020-45, which is not yet available on the Immigration New Zealand website. We imagine it will be there, if not later today, then probably Monday. It seems to be sort of the time they take to get these things published. And they make changes to H5 2515 of the operational manual. And that change would make these people eligible for falling under the roles as a critical purpose for travelling to New Zealand allowance. They then provide more detail in H535 in the operational manual. Now, there is 5 basic requirements for a person to be eligible to enter New Zealand under this new exception. They need to still have their employment, so they need to have maintained it while they're out of the country, still have that job. And for the entrepreneurial work visa holders, they need to still be operating the same business that they were operating for the entrepreneurial work visa. They need to have left New Zealand between the 1st of December 2019 and 9th of October 2020. So those looking to leave New Zealand in the future and then come back in again, this exemption will not allow you to re-enter. It's only those who are currently outside who left on or after 1 December 2019. They need to have held an entrepreneurial work to residence or essential skills work visa, with the essential skills work visa being mid or high skill level. When they departed the country, they need to have been holding a visa at the time they left. They don't need to be holding a visa right now, because the next one is that they have to either continue to hold the visa or have applied for a further visa that allows them to work in that same job, operate the same business. Now, as we know, the applications from Offshore stopped on 9th of August, so they would have had to have applied for that new visa prior to 9th of August. So if, for example, they had left the country in mid-December, gone home for Christmas, their visa was due to expire, say, in February, they applied for a new work visa, COVID came in, border got locked, processing stopped, then they would fit under that requirement to have held a visa when they left and to have applied for a new visa to allow them to keep working. And they have to have met the time in New Zealand requirements, which we'll come to in a moment. Now, this allowance also includes partners and dependent children if they currently hold or held at the time of departing New Zealand visitor, work or student visas based on their relationship to the work visa holder. Now, it doesn't mention the need to have applied for a new visa, which is an interesting difference. So the main applicant has to have applied for a new work visa. The partner and dependent children isn't mentioned that they have to, which is whether that's been overlooked or is deliberate, we're not sure. But this would allow them to apply for an exemption, and we'd hope then apply for those for a new visitor visa, work visa under partnership or student visas. And any children born on or after 1 December 2019 can also be included. So they, of course, wouldn't have had a visa. They can be included, but you need to get their passports sorted out so you have a passport to put the visa in or to attach it to. Now, the time requirements, the time in New Zealand requirements are in H5 3035E. I think I've written that down wrong, but yeah, that's where I think they're going to be in. It requires that the applicant was in New Zealand for at least 273 days in each of the 2 12-month periods immediately preceding the date of their departure from New Zealand. So to be clear, this is not in the 2 months from the 2 years prior to today, or the prior to the time the application is made for this exemption. It's from looked at from the day they left the country. So if they left on, say, 15 December 2019, then they look at between 15 December 2018 to 2019, that 365-day period, and from the 15th of December 2017 to 15th of December 2018, that year. Were they in New Zealand for 273 days in each of those 2 periods? So that's how they calculate it. So people won't be penalised for being kept out of New Zealand for the border closure, and that time out of New Zealand during the border closure won't be included in one of those 12-month periods. Those 12-month periods start from the day, are calculated from the day that you left the country. Now, for some, they may only need to show 273 days over one 12-month period. So that would be for applicants with an entrepreneurial work visa at the time of departing New Zealand and were operating their business in accordance with the conditions of their visa and continue to do so while out of New Zealand. Also, those who have 1 or more dependent children with them for at least 6 months in that 12-month period. So if they have no children with them in New Zealand, then that would allow them to just have that one 12-month period to consider. Those with parents or siblings who are 18 years of age or older, who are currently in New Zealand or are ordinarily resident in New Zealand, or those who have submitted an application for a residence visa on or before 9th of August 2020, of course being the day that the offshore applications were stopped. All those people only need to show 273 days in one 12-month period, not two. Now, just to make sure things are clear, a work to residence visa also includes, of course, those who are applying through accredited employers, those who have an arts, culture or sports work visa, long-term skill shortage visa, skilled migrant job search visa, South Island contribution visa and global impact visa. So these are all eligible under this change if the requirements are met. So this change should let a number of work visa holders to return to New Zealand. I know a number of you are stuck offshore and your employers want you back, so that is great news. Now, in regards to residence, there is a change for those who were granted residence while offshore when they previously had an essential skills work visa, entrepreneur work visa, or one of those work to residence visas I just mentioned. So under the border control rules, residence visas that have not been used previously do not allow someone to enter New Zealand. This has been, people have been caught out with this, where they've been offshore, been granted residence, and they have not entered New Zealand on the residence visa. The residence visa is therefore not activated and they cannot enter New Zealand. Those who had been to New Zealand already on a residence visa can enter. Now S5.5.1 is now going to allow for those people to apply for a border exemption, provided that they still hold the job they held the work visa for, or the essential skills visas, or the types of work to residence visas, or they run the business they had the entrepreneur visa for. Now this will be likely a very small number of you, but if it is one of you, then please get in contact with us and we can go through the changes in a bit more detail. These are also mentioned, covered in the same amendment circular I mentioned earlier, being 2020-45. And that is it for today. Probably some great news there for a number of you, while others are still going to be waiting for something. As we suspected, we're hearing that the next area to be looked at will be student visas. Now, we don't know the details yet, so don't be looking at applying next week or applying and be coming to the country within the next few weeks. We don't know the details yet. We're waiting to find out more. Hopefully have more details in the next week and we'll bring them to you when we have them. Until then, kia kaha, stay strong.